So what's the difference between patent pending and patent issued? Hi, I'm JD Hovener, owner, founder here, patent attorney at Bold Patents Law Firm. Happy to share with you my expertise over this past 10 years of working with inventors, business owners, helping them achieve almost 500 patents as of today. I'm also the author of Bold Ideas, and Inventor's Guide to Patents. And I put together a really cool Inventors kit for you to download. Just click below. That'll get you access to the whole PDF, as well as some really cool tutorials on patent searching and patent application drafting. So this question about the terms patent pending and patent issued, just to make sure we clear up any confusion. Patent pending is, those two words are magical. As soon as you have any patent application file in the US, you are pending. Doesn't matter if it's a design patent, a utility provisional, a non-provisional, or a plant patent. As soon as its application is submitted properly, and there is a receipt, okay, the USPTO confirms that it was submitted, right, either with an electronic receipt or with a formal, written receipt, then it is pending. And you may use that designation on physical products and digital products. So that's what patent pending means. And you're pending until the application is either in an abandoned state, expired, or if it is now in a mode where you need to respond to an office action, or it will go abandoned. So you have some major issues to face if you're up against that, and we'll talk about that on a different video about how to respond to office actions. Now, this other term called patent issued. Patent issued, that's when you get to the end of the line. That's when the patent office and the examiner have already allowed the patent to issue, and now they say, okay, all you have to do is pay this final issue fee, and it will be recorded as a unique patent number. Now, on the utility side, there's been over 11 million patents issued. So you don't get that number, that patent number, until you've gone all the way through and gotten the patent issued. So that's what that term means. And usually as part of that process, you'll get a really clear definition in terms of how much time you have to enforce your patent rights. And again, those patent rights are the ability to exclude anyone else from making, using, selling, or importing your invention into the US. So you get that bundle of rights as soon as it gets patent issued. And it's, for the utility side, it's 20 years from the date of filing in the non-provisional. Okay, so typically if that takes a year or two, let's say, to get through the patent office, you have 18 years ballpark to enforce your patent after it gets patent issued. On the design side, it's 15 years from the date of issuance. There is some more work to do if you have a utility patent in terms of how to maintain the enforceability. So after it gets issued, if it's a utility patent, you have 3 major periods where you have to pay maintenance fees to keep the patent enforceable. Otherwise, it will expire early. On the patent pending side, it is fraudulent and illegal to mark a product as patent pending if it's actually abandoned or expired. So there are some major fraudulent mismarkings that you can be liable for if you're not careful. So physical products, make sure you're labeling them only so long as when you apply that label, the patent was actually still pending. And once it gets issued, you should clearly label it with US PAT, abbreviation, or patent, and the full patent number. Now, you're not going to get in trouble if you have a patent that's issued and you still have patent pending on some products that are being sold. You just want to update that to put anyone on notice. And the reason why you want to label is not so much to impress the potential customers. It's really actually to put the bad guys and bad gals on notice that if they decide to infringe, even though it's obvious and they've been put on notice about your patent pending or patent granted, issued, I should say, you will be able to allege that they were willfully infringing. And in a cease and desist letter, you can threaten additional damages because of their willful infringement. The federal government has provided additional, and the judges and all around the federal circuit have provided additional damages circumstances where the infringer really is being a bad actor and is knowingly taking action against you to infringe your patent rights. Hope this was a fun example of how to, these two terms that seem like you might know what they mean, patent pending and patent issued, can take another 2 or 3 steps further down the road. So if you want to have any questions answered, please put them in the comments below. Again, download that Inventors kit and take action today. I'm JD Hovener with Bold Patents. Have a great day, everybody. Go big, go bold.